What's up? Good morning, everybody. It's about 6:30 in the morning, Tuesday, January 9th. We've been on the road for quite some time, heading to the Victorville Courthouse for preliminary hearing day 4 for the Justice 8. Those are the 8 individuals who are being targeted and harassed by multiple departments, many departments that they were trying to hold accountable, many departments that when victims of who were street vendors and had violence against them from others could not get accountability. And there is a group of people, many of them, that when they hear this, they show up. I'm someone, when I hear someone is a victim of systemic injustice, I show up. I've traveled the country to stand with victims, to help them raise money. I have no doubt that the individuals and people involved believe in transparency, believe in accountability. I believe this is, without doubt, retaliation and harassment. 7 of the 8 individuals have been denied bail. Child molesters get bail. Derek Chauvin, who murdered George Floyd on video, got bail. People who kill people get bail. So the idea that they're being denied it seems unreasonable. It seems unconstitutional. There's been many warrants served in this case, from houses, social media accounts, text messages, cell phone carriers. The detective alleged that there was a warrant that has found some type of approximate location when phone calls are made from Eden's phone. On cross-examination, it seemed that there isn't so much clarity or specifics known about this at all by the detective who shared the information. So it'll be interesting to see how they plan to use something it seems they don't know that well against these defendants. We've heard many of the detectives and people involved in the lead investigation of this case testify through cross-examination that they had made mistakes in their testimony, that upon further review of evidence, of video, that they were able to find that they were mistaken in some of their testimony after being cross-examined by these defendants' counsel. So this case is very important. You don't have to agree with everything that these individuals say, do. You didn't have to be there. If you hold any value in our constitutional right to critique our government, to hold our police accountable, to want transparency in these different departments, which does not exist. This is not the opinion of these 8 individuals. Transparency with police does not exist. Accountability with police does not exist. So the idea that we can confront these issues and be held liable in the court is unconstitutional. It's an abuse of authority. It's an abuse of the court. It's an abuse of the system. And as I look at these 8 individuals, is it possible that not 100% of them are innocent of 100% of the allegations? Not saying that, but I'm saying that they are being treated unjustly in this prosecution, and that the whole essence, I believe, that this prosecution stems from is something that is unjust. I wish that the department used the same energy to the people who were wanting to file complaints, like the street vendor that some of these individuals had to show up for because of the lack of accountability that the department was responsible for. In fact, they wouldn't even give the street vendor a police report, as far as I understand it. The vendor who had the altercation with the first Jon Doe 1, who's one of the least credible witnesses I could ever imagine. I don't think any of this would have happened if the cops just listened to the actual victim, the street vendor, I don't think this would happen. In fact, witness one was not working when he started harassing the street vendor because it was because his tent was like a couple inches on some dirt off a curb. Okay, the security guard, Jon Doe 1, was not even on the clock patrolling that area. He doesn't even have a valid guard card. He has since been fired. He's seen what I believe is to be smoking marijuana while driving his vehicle. I don't believe that this is a credible source, and I think the idea that this prosecution seems to be weighing very heavy on people who would clearly be biased makes me question the validity, the morality, the lawfulness of this whole prosecution. So those are my thoughts as I drive into Victorville, day 4 of the preliminary hearing for the Justice 8. We hope that they can be released on bail. We hope that the 7 being denied bail can be released. That is the goal today. They should not be in jail. They should not be charged, as if they are guilty. No, they have not had their day in court. They have not had a jury trial. I hear the detectives say they're still investigating things. They're still subpoenaing. They're still looking through records. They're still figuring out who sent what. So there's more to this. We all should learn more. We should all be concerned about this use of authority in the courts. And we should make sure that the police are held accountable. My name is Senate, also known as Mr. Checkpoint, Executive Director of the AFTP Foundation, AFTP.org. I appreciate your support. Subscribe to the YouTube channel and stay tuned as we keep uncovering and breaking news in this developing story. It's day 4 prelim, Victorville Court. We're on recess. Let us know.
Okay, guys, Nicholas Rosenberg here, Eden, Alex, and Alvarado update. Right now, the evidence is closed. We've heard from 5 or 6 witnesses, including Detective Duran. And what's really interesting about Detective Duran is on direct, he says one thing. On cross-examination, he said some other things. But I want to give him credit because on cross-examination, his answers have been helpful. I'll give you an example. On direct examination by the DA, he didn't know what monetized or monetization was. However, when I asked him about, can you make money from YouTube? Can you make money from social media? Would that be called monetized? He said yes. And then I asked him, and so you know what demonetized means? He said yes. So that was a little punch. Another example is on direct. He said that Jon Doe 2 said, if you don't apologize, I'll beat you every day. However, when I asked him about that, he said, well, let me just clarify. I can't tell if it's I'll beat you every day or I'll be here every day. So once again, that's another punch. So right now the prosecutor has done his argument to the court as to why she should hold every defendant accountable, hold them to answer, and go towards trial. Now the defense lawyers have their chance to argue to the judge about why charges should be dismissed, and critically, why their client, including my client Alex, why they should be released from the no bail hold. So by the end of today, we should have those answers. Nicholas Rosenberg, punching back.
Well, there was one discrepancy regarding a translation. Can you tell me?
Yes, that's another good point. So on direct, the officer translated, I forget what it was, sabemos hacer casa way, and he translated as we know where you live, bitch. But actually, on cross-examination, he changed it and said that it also could be way, could be bro, not just bitch. So on cross, he's admitting to and saying more helpful things. Nicholas Rosenberg, punching back.
Para los cargos que proceden a juicio, aquí en estos acusados, incluyendo el muchacho enamorado, Duran y otros, quienes son activistas, son personas quien abogan por vendedores ambulantes, las personas quien son bien humildes y están aquí porque ellos son las personas quien apoyan, ayudan y son las personas que vienen para la defensa cuando son los atacados.
Legalmente, ¿cuál es la defensa de los 8 arrestados?
La defensa es que la actividad aquí es actividad protegida bajo la primera enmienda, First Amendment, es lo que estamos hablando. El derecho de...
Está protegido bajo la Constitución, me puedes decir.
Sí,
empezamos,
sí.
Sí. Bajo la primera enmienda, ¿sí?
Enmienda.
Okay. Te lo pregunto otra vez, ¿sí? ¿Cuál es la defensa de los 8 arrestados?
La defensa es bajo la primera enmienda, el derecho de dar y proteger las personas como vendedores ambulantes.
Y bajo la primera enmienda, ¿cuál es la defensa que tienen ellos?
La defensa es que estamos diciendo que la actividad que ellos estaban haciendo está protegida porque ellos pueden manifestar y pueden estar en protestas y es lo que estaban haciendo por la mayor parte.
Ya, entonces, pero no tienen fianza todavía. ¿Por qué no tienen fianza?
No hay fianza porque la juez dijo que ellos son una amenaza al público.
La juez dijo eso.
La juez dijo
Ya,
eso.
ya. ¿Y crees de que los cargos crees que los cargos que ellos enfrentan justifican que no tengan una fianza todavía?
Claro que no. Aquí miramos unas personas quien no mataron a alguien, no asaltaron a personas si había una herida seria, estaban protestando, estaban manifestando y no se merece una fianza en este caso.
Ya, okay. Entonces, ¿qué va a pasar ahora? ¿Cuándo concluye la audiencia preliminar?
Ahorita ya estamos concluyendo. El procurador dio su argumento final. Ahora los abogados vamos a presentar el argumento final y pedir que los cargos se retiren y también que haya fianza en este caso.
Okay. ¿Y hay alguno de los 8 que esté fuera o no todos están todavía arrestados?
Uno está afuera, pero 7 no.
Ya, okay. Ok, perfecto.
Gracias.
Pues, okay. Entonces, Dan, please. Okay, we're going to start over here. Okay, thanks. Okay. 5, 4, 3, 2, 1. Okay. So Dan, thank you for this interview.
Good to see you.
Tell us. I mean, this case. I mean, it definitely underlines, obviously, protections by the Constitution versus, what the DA is saying. What do you say is the main difference here between what they're saying and the charges that they're facing versus your defense?
Well, I think it's twofold. Number one, it's clear from the videos that were played that none of these activists simply went out and started committing these acts. There's a lot of provocation we saw in the videos from the people they were interacting with that escalated this situation. The second thing that I've had a problem with from day one is the fact that the prosecutor is trying to act like all of these individuals are acting as a cohesive unit, and they're lumping them into a group. And sort of obliterating all the individual characteristics of not only the individuals, but what their responsibilities were, what they did that day. And that's a matter of characterization. We can't let the prosecutor get away with simply treating all of these individuals the same. This conspiracy theory, and I think I speak for most of the defense attorneys on this case, is paper thin, that there was ever any sort of informal agreement. These people were activists. They were called out individually. There were posts made about coming to a certain location to demonstrate, and that's what they did. The prosecutor, especially as to my client, has introduced no evidence to suggest that my client signed up for this, actively participated, encouraged this activity. He simply showed up at the Victorville incident because that's his passion and what he wanted to do.
So, what do you expect to happen tomorrow? What do you think the judge is going to do tomorrow with, with all of the preliminary evidence in front of her now?
Well,
what is your expectation?
Well, I'm only going to speak as to my client. Obviously, everyone here has their own client, their own strategies. And maybe we'll get a ruling as early as today. I hope so. I hope it doesn't go over till tomorrow. And although I hate to speculate, I sat through 4 days of testimony and frankly didn't hear or see anything that my client did with respect to the Pomona incident. He wasn't present. He didn't send any messages of encouragement or assistance to those that were there. So my hope is that at least with respect to that incident, these charges will get dismissed because there really hasn't been any evidence tying my client to Pomona.
What's your perspective on the fact that there's no bail set for any of the people that are currently detained?
Well, that'd be a lot longer interview than you're going to want for me to answer that. But what I will say is, and I know I speak for everyone here. Everyone here is a highly experienced criminal defense attorney. I've gotten clients out on bail in cases far worse than this with horrible facts, with people committing extremely violent offenses, and I know my other co-counsel have done that as well. So the fact that these individuals, after almost a month, are still sitting in custody, many of them with minimal to no criminal records, is absolutely, to me, unprecedented under the bail laws as they should be applied. So as far as I was concerned, I think almost all of these people, and perhaps even all of them, should have been released when my client was released on December 28th. There's just, to me, no legal justification for it. Yes, Mr. Acevedo is here.
Would he be able to, would you allow him to make a statement or you prefer not?
You know what? I know the court has put very strict restrictions on him and what he can do as a condition of being released, so I don't want to jeopardize that for him.
I appreciate it. Okay,
I appreciate that. Thanks, Sal. I appreciate talking to you. Take care.
Okay. Y si hablas en español podemos hacerlo, ¿sí?
Inglés.
Okay. Okay. All right. Okay. Tu nombre? Your name.
Yes, hi, I'm
Hold on a
Nicholas.
sec, please. Hold on a sec.
That's better.
Okay, and rolling.
Okay.
I am Nicholas Rosenberg. I represent Eden, Alex, and Alvarado, who's alleged to be the ringleader of a conspiracy to commit not one, but now it's 3 target crimes. And the district attorney keeps embellishing, adding new charges, changing the scope of the conspiracy. So we have our opportunity to argue to the court for dismissal of all charges.
What was your, what evidence or how did you argue against the charges against Alex?
So we haven't done our arguments yet. I'm going to do that after the lunch session. Actually, the lawyers are going in kind of reverse order as we did during cross-examination. But here's the arguments. I'll give you the one sentence. Basically, what we have are activists exercising their First Amendment rights. There's 2 fistfights, and there's one person who throws a bottle at the activists, and he ends up getting on his knees and apologizing. So that's really what we have here. So for purposes of bail, I agree with all my colleagues. It's outrageous that my client, as well as the other Justice 8, Justice 7, because Mr. Acevedo's out of custody, are being held without bail. And that's something that the community is very aware of, very sensitive to. And the mood is outrage. I'll use the word injusticia.
Okay, very good. I appreciate it very much, okay? Thank you very much.
And then Nicholas Rosenberg, and as I've been saying during the life of this case for my client's advocacy, confrontational is not criminal. Confrontational is not criminal.
Okay. All right. Thank you so much.
you.
We
No
appreciate it.
problem.
Thank you.
So the update is it could have ended at 5 p.m. It's right now 4:30. They ended it about 30 minutes early because the prosecutor wanted some more time. So preliminary hearing for the Justice 8 Day 5 tomorrow starts at 1:30 p.m. 1:30 p.m. in the Victorville Courthouse. Stay tuned, and if you can come, pull up Victorville Courthouse at 1:30 p.m. tomorrow, and it's supposed to end. Hopefully they come home.
Okay guys, Nicholas Rosenberg here, Victorville Courthouse, day 4 of the preliminary hearing. I represent Eden, Alex, and Namorado. And today, the district attorney finished the case in the morning. We came back, we did a little bit more than we did our closing arguments, where we're making motions to dismiss all charges based upon insufficiency of the evidence. The standard at preliminary hearings is very low. It's called probable cause, and that's the same level of suspicion to get a search or an arrest warrant. We sometimes call that the strong suspicion standard. So I presented my argument to the court as to why she should dismiss all of the charges. So the charges come in 2 basic groups. The first charge is a conspiracy which has a target crime of criminal threats. Now the district attorney wants to add stalking and harassment as well as assault by means likely. So now the conspiracy from September 3rd is to commit criminal threats, assault, and harassment. So this is something that they did at the close of evidence. They're allowed to try to amend the charging document to conform to the proof. So every conspiracy is an agreement plus at least one overt act. Now they have some overt acts alleged in San Bernardino County, and if you remember, September 3rd, all of the incidents occurred at the Pomona, in the city of Pomona, Los Angeles County, either at the El Supermarket or nearby, or at the Pomona police station. So if you're asking yourself, why are we in Victorville? The answer is that the San Bernardino County authorities are relying on one overt act that they claim happened in San Bernardino in order to get jurisdiction and venue here. So virtually every attorney has been arguing against that, and that's an issue for the court. The district attorney's claiming, well, actually, the district attorney's witness, Detective Duran, who's the all-star witness for the prosecutor, he said that the criminal conspiracy started when the protesters, again, I say activists, were in front of the Pomona police station. This would be at about 3 p.m. that afternoon. But they're claiming that my client made a phone call that pinged to San Bernardino County before that. So that cannot be an overt act for that conspiracy. And why not? Because an overt act has to happen after the conspiracy has been created. So therefore, that's one less reason why they can stay in San Bernardino County. So the next issue is they claim that my client transported a pepper spray gun to the county of San Bernardino. Again, that would have had to have happened prior to the overt act in front of the police station. So basically, we may have them on the ropes as far as why are we in San Bernardino County. So the lawyers did a pretty good job today of divvying up the issues. Each lawyer didn't repeat the same arguments as the others made. And if we're able to shut down the conspiracy, then their whole case kind of falls apart, and then we're left with non-strikes occurring in the city of Victorville. Now, my client is charged with a few strikes, about 3 strikes, but all of those are from September 3rd, LA County. So once again, if we can shut that down, then we have a more manageable case. And the other news is that I did file another bail motion in which I'm asking the court to consider releasing my client on his own recognizance with an ankle monitor, stay off social media, and do not associate with the victims and or the defendants, except for Miss Lujan, who's his significant other, and they have a child in common. The alternative argument I'm going to make is to ask for cash bail set at $80,000. That is an amount that my client can afford. The worst, most draconian set of facts is if the court sets cash bail with ankle monitor and the other terms. But if that were to occur, then my client would be released, and that's what we're trying to do here, guys. Okay, so Nicholas Rosenberg, day 4 of the preliminary hearing. Tomorrow we will finish after the judge makes her ruling as to which people have which charges, and she makes holding orders, meaning the case can go forward to trial. We get to finally relitigate the bail issue. So keep us in your thoughts and prayers. Vamos a orar. Nicholas Rosenberg, punching back.